One see. Immovable property. All have joined?
Yes, sir.
Yeah, all of you joined it?
Yes, sir.
Yeah, we can proceed now. So you are required to produce certified copy of the decree as well as certified extract from collector's office under order 21 rule 22. 22 you are required to produce certified copy of the main property itself. The property card details must be certified copy, not original, because this is a primary evidence under the provisions of law. Now, where your certified copy you are required to produce along with the application for amendment, please read that here. Uh, mm, mm. See, order 21 rule 17 says the court will remove the defect 7. When application is presented, it will see that compliance are being done here. It's like an application for amendment under order 16, order 6, rule 17. You amend your pleading plain written statement. Now, executing court has power to remove the defect, allowing the amendment. See that here? That amendment procedure is decided by the court under order 21, rule 17, 1 and 2. See, subclause 2 speaks of here where the application is amended. 17.1 May, you file the application complying with the requirement of 11 to 14, which we discussed right now. Shall we file defect in the state? Then remedy the defect under rule 1A. Otherwise, application will be rejected. Provided the application, some inaccuracies are there decided in the court, amount decreed so and so, make an order for execution decree. So all the inaccuracies you have to remove. Then subclause 2 permits the amendment of the application. Then subclause 3 says every amendment under this rule shall be signed by the judge. Then after the removal of objection, granting of the amendment, the court is normally liberal. Suppose straight away application rejected, it will give scope for red tapeism and corruption in the court of law. That is why an opportunity is given to the decree holder. So आपकी application में objections हैं, namely certified copy नहीं है, plan is not there, description of the property is not there, you have not correctly mentioned the application. Please remove it. Affidavit is not there. If you are seeking the arrest of the judgment debtor, order 11, order 21, rule 11A says affidavit must be filed setting out the ground of arrest. That affidavit is mandatory. Then uske baad application comes for hearing, application will be added. So in this provision, see there here, this I am saying application under order 21, rule 11, where notice is not called upon to hear. It doesn't say that notice will be heard. Court will straight away admit the matter. Admit or may reject. If you are not complied with the requirement, 4 के अंदर admit करेगा, execution of the decree accordingly will follow. So the court will order execution under order 21, rule 17, subclause 4. This is one procedure where issuance of notice to others is dispensed with. Now the second provision you come to under order 21, rule 22. This also application is filed under in form number 6 of appendix E. So name of the suit, party's name, decree has been satisfied, cost hai, no appeal, no stay. So final hone ke baad, no mode of execution. So this application is normally filed after 2 years. In cases it is filed 2 years, you come under 22, in which case the court will issue notice. Or the notice is also, this application also issued against the heirs and legal representatives of the deceased, which we learned when they are dead. वो मर जाने के बाद under section 146 we learn the heirs can be brought on record. Then also application against the assignees, against the assignees basic है. Also an application under 44 foreign decree के अंदर. So this application requires that notice can be issued to the judgment debtor before execution. But proviso कहता है कि in certain cases the court may exempt the, if a case is made out by the decree holder that notice should not be issued, it will delay and defeat the execution. The court may in its wisdom say that notice is not required to be issued. So it is the discretion of the court. But normally the courts insist that here notice should be issued. Now, once the application under Order 22, Rule 2 milega, then you have to follow the provisions of Order 21, Rule 37. Now, please come to Order 2137. Now, one of the mode of execution you sought is arrest and detention of the judgment debtor in civil prison. Now, the court will say that here, before putting this man in jail, notice can be, show cause notice will be issued. The court will issue show cause notice as to why he should not be committed to civil prison. Huh? Order 21, Rule 37 में देखिए आप, why he should not be committed to civil prison. But proviso again says, if the court feels that, if the decree holder is satisfied, issuance of notice will delay and defeat the proceeding number 1, or the judgment debtor will run away from the jurisdiction of the court and he will not comply with the decree, and your lordship may kindly dispense with the notice and straight away execution may be followed, and warrant of arrest may kindly be granted. So this is the language under 2136 and last के अंदर subclause 2 check करें आप, where appears is not in obedience of the court shall, if the decree holder so requires, issue warrant for the arrest of the judgment debtor. This is one case where the court dispenses the notice. Otherwise, the procedure under Order 22 in the city of Bombay, in my practice for several years, for more than 3 decades, the judges normally under 21, 22 would like to issue notices. They don't like to go ex parte. They are very careful. They see to it that the other side should be heard. Then under 21, 22, one more procedure followed is here. Then Order 21, then see the provisions of 23. Procedure after issuance of notice. Now, what procedure the court follows after issuing notice? The judgment debtor has opportunity to file his objections. Kindly note that he has a right to place his objection as to why decree should not be executed. That means it is open for him to take up the plea that here the court has no jurisdiction, that decree suffers some nullity. This court is not competent. Under section 47 में पढ़े हमने, you all objection can be raised and take up the plea that here this property cannot be attached. It is coming under the exemption clauses. Why arrest cannot be effected? All objections are considered by the court, not by way of a separate suit that you learn under 47. You cannot delay the proceeding here. So after the court hearing, normally there is no defense in execution unless a gross mistake is committed by the decree holder and on the court. Okay. Then after hearing both the parties under Order 21, Rule 24, the court issues process of the execution. देखिए, process. Issues process. Yes, the decree can go ahead. That means fit for execution. The court has rejected and repelled the submissions of the judgment debtor. Mind you that here, the order passed by the court, both under the provisions of Order 21, Rule 17, allowing the application for execution, and Order 21 and Rule 24, they are not specifically appealable orders. They are not appealable order because if every opportunity is given to file appeal, that will delay the proceeding. So the court can decide all these objection under section 47, all objections to objection. Now finally, section 21, the court makes an endorsement of the process. Mean application for execution has been made by the decree holder under order 21/22. The court has heard the objections of the judgment debtor. After hearing the judgment debtor, court has issued process. That means the notice has been made absolute. If the court wants to reject it, court will say that yes, the decree cannot be applied, execution cannot be issued for the reason that here the court lacks jurisdiction, which fact was not noticed earlier. Or the mode of execution does not fall any of the mode under section 51A. So normally execution is issued here, then उसके बाद क्या होता है आपको मालूम है. Then the bailiff of the court, see that here the execution proceedings, the fruits of it can only, you cannot just go and throw the defendant out, plaintiff. You will have to go through the court's officer who is known as a bailiff. क्या नाम उसका नाम क्या? Bailiff, BAILIFF, bailiff. In the city of Bombay, all process of the court is executed through the office of Sheriff of Bombay, which is situated on the ground floor of the City Civil Court Bombay, a sheriff's office. Sheriff has officers who are known as court bailiffs, both under the High Court rules and City Civil Court rules. You will find this. The officers responsible for serving the writ of someone's execution proceedings. So you will have to take the bailiff. He will go and execute the decree. He will go and perform this act and not anybody else. Unless the court has appointed a court receiver, receiver himself go directly. A receiver need not take the bailiff. Receiver himself has wide powers under order 40 rule 1 CPC. समझे ना आप? So a decree holder cannot take the law in his own hand. अरे मेरे favor में decree हो चुका है, I will go and throw him out. You cannot do that. Okay, application should be lodged with the sheriff's office in the small causes court Bombay. On the ground floor, there's a bailiff office. Execution department sends it to the first floor. Then the application is processed. Then appointment is fixed with the bailiff. Then the plaintiff or the representative goes along with him, and to execute the warrant, the warrant of possession, a warrant of arrest, and warrant of whatever order the decree has been passed in that regard. So this is a little cumbersome procedure which you have to follow before the execution. Anybody want to ask any question?
So, Ashish here.
बोलिए.
Sir, what happens if an execution is stayed because of lack of jurisdiction, because a separate suit cannot be started? So what happens, sir?
Yes, that procedure is here in CPC. That's the next procedure I'm going to take. When the executing court can stay during pendency, that I will take it up now. Now I'll just tell you that here. Now, stay of execution is an important topic which you asked me. Now take down. Number one, when after passing of the decree, which court can grant a stay order? Number one, first provision is under order 41 rule 5 subclause 2. Mansi, please can take it under order 41 rule 5 subclause 2. This is at the time when the defendant wants to file an appeal. The executing court itself stays the decree. समझे ना आप? Order 41 rule 5 subclause 2. Stay of execution by the court which passed the decree. You got it? Huh? This is one provision, order 41 rule 5. Then under order 41 rule 5 sub clause 1, वो executing court का order 41 rule 5 sub clause 2 है. ये then order 41 rule 5 sub clause 1 is the appellate court to power to stay the execution pending the appeal. Merely because you have filed the appeal, stay will not follow. Certain terms and conditions are to be followed here. The court may say order deposit of the money if it's a money decree. It's an immovable property. You have to give to the court an undertaking. You will not create third-party interest. You will not alienate that you will deposit money in the court. You will not occupy free of charge. So condition order 41 rule 5(1) में appellate court है. Order 41 rule 5 sub clause 2 executing court. But then next is a transferee court can also grant you stay under order 21 rule 26. Mansi, can you please open order 21 rule 26? Now under order 21 rule 26, as you said, Bombay court passing a decree, the decree is sent to Delhi court under section 38 for execution. It's a transferee court in Delhi. In Delhi, the execution application is taken out. Huh? So before the execution proceeds here, the judgment that the executing court, transferee court can stay the execution under 21-26. Number one, why? Either to allow him to file the appeal or raise objection. Okay. Then another provision for a stay execution is a order 21 rule 21. Where there are different courts. Order 21 rule 21 में check करें आप. 21 stay of execution pending suit between decree holder and judgment holder. So these are the only 1, 2, 3, 4 illustrations. Stay of execution can be granted by the court. Then there is some provision in the appeal where a stay can be granted. Just I will take you to that here. एक minute. Stay of execution. Then order 21 rule 59 check करें Mansi. Order 21 rule 59. मिला आपको? Stay of sale. So this is another provision where a sale can be executed. Now when the sale can be effected, I would like to tell you, आपका application तैयार हो गया, bailiff has gone effected, attach the property. Attachment takes place under order 21 rule 54. Mansi, please open 2158. Order 2154 ले लीजिए आप पहला. Order 21 rule 54. ये हो गया attachment. The next step it is. उसके बाद under order 2154 attachment के बाद adjudication of the claim is given. Order 21 rule 58. Kindly see that. Order 21 rule 58 adjudication of the claim. Here also, while education 2158. Now the judgment dictator can raise all the objections here. So pending the hearing and final disposal of the objection, the executing court can stay the sale under Rule 59. Okay, Order 21, Rule 59. आप समझे ना आप? Then where you can apply to the court for sale, Order 21, Rule 82. Important. Which court you can apply? See, Order 21, Rule 82. इसके पूरे फॉर्म्स आपको मिलेंगे in annexure we learned here, annexure E, F, G again. Then what you have taken? Order 21, Rule 82. It says that see, immovable property can only be affected by any other court, but not the small causes court. Okay, attachment can be done. Now, attachment ke andar, when you approach the court, attachment ho gaya under 54, adjudications were held under Order 21, Rule 58. Then Order 21, Rule 66 ke nikaliye aap. Order 21, Rule 66(3). Proclamation of sale by public auction or private auction. Please note that here. Subclause 3 कहता है कि application for an order of sale under this section shall be accompanied by statement and verified banner before so and so. So this is the gamut of the procedure. Now ये sale होना क्या? Third party, when can you stop? Now one more proceeding for stopping the sale. Section 69 check करो आप. Section 69, sorry, Order 21, Rule 69. Order 21, Rule 69, subclause 3. Now, subclause 3 के हिसाब से, before the confirmation of the sale, if the money is deposited by the judgment debtor and before the knockdown takes place, sale can be stopped. This is another examples of stay. Then Order 2183 check करें यहाँ पे. Order 21, Rule 83. Postponement of sale. So you learned under Order 21, Rule 66, there is a proclamation of sale, either by a public auction or a private treaty. ये करने के बाद, then there is a postponement of sale. This is the provision relating to sale. Then application to set aside sale is a Order 21, Rule 89. The judgment debtor may come say that I have brought money, I want to deposit now. Your lordship may kindly set aside the sale. He takes out a chamber summons in the High Court or interim application now. Under Order 2189, he can tell the court. Or under 90, sale can be set aside on the ground of irregularity of fraud. Fraud cannot be played. Now, there is an inbuilt prohibition. A decree holder cannot, he cannot buy the property. Isn't it? We learned last time, under Order 21, Rule 72 में पढ़े हमने, you cannot purchase the property without the permission of the court. So you are playing a fraud. I mean, a property worth 1 crore, in a private treaty, you are purchasing it for 50 lakh. You are causing loss to the judgment debtor. So when fraud is being played, then application can be filed for setting aside the fraud under the provisions of order 21 rule 89. 90 speaks of setting aside sale on the ground of fraud. And no sale to be set aside on the ground of fraud without notice to other side. Full particulars to be mentioned. See here, before the sale becoming absolute and property is attached, a third party's property which is attached, who is not connected to the suit, he is not a garnishee. Garnishee means a person holding the property of judgment debtor. A judgment debtor of the judgment debtor is called garnishee. Suppose you are a defendant in a suit, आपका 1 लाख रुपया मेरे पास है. You have entrusted me 1 lakh rupee to keep aside. So the plaintiff comes to know after execution that your 1 lakh is lying with me. He can come and attach that 1 lakh in my custody. That is called I am a garnishee. But if I take up the plea that year, that 1 lakh has no connection with the judgment debtor. This is my independent property, exclusive property, and the flat which is in occupation, mera flat hai, and not her flat. A separate suit can be filed under order 2192. Please here, third party, subclause 4. This is the only one provision permitting a filing of a suit. Otherwise, during execution, you are not allowed to file a suit. Kindly see that order 2192, it speaks of application for setting aside. Then subclause 3, देखिए, no suit to set aside shall be brought by any person under the order. That means a person claiming, decree holder and judgment debtor or legal representative, they cannot bring a suit. But subclause 4 check करें यहाँ पे 2194, where a third party challenge the judgment debtor's title by filing a suit against auction purchaser, the decree holder, judgment debtor, necessary parties. Suppose the plaintiff has filed a suit against B and he took possession, certain possession belonging to C. The C will take up the plea that here the sale is fraudulent. It is my independent property. So he has to join not only A and B and also the auction purchaser C, and the D is a third party. So यहाँ पे A, B, C, D 4 आदमी आ गए. The decree holder, the judgment debtor, the auction purchaser, and finally the suit is being filed by a third party. Third party whose property has been erroneously or wrongly attached, who is not concerned, who is not a garnishee, who is not a trustee of the original defendant. So this is the only provision which permits filing of a suit. Otherwise, all questions are to be determined under the provisions of order section 47. Again, just quickly run through Mansi section 47 for the benefit of the student. They should, before they forget it. Kindly see that here. Questions to be determined by the executing court in decree. All questions arising between the parties and suit and decree was passed so and so shall be decided by the court, by the executing court, and not by a separate suit. So you are forbidden from filing a suit, but suit is allowed to be filed only by a third party under the provisions of, right now padhe abhi humne 21. Third party can challenge it. Okay, these are the provisions which probably next lecture I will be closing this chapter with regard to execution, dealing two things. Number one, garnishee proceeding, or lengthy, a third party proceeding. How third party also has a liberty to take out notice under the provisions of order 2145 ABC वो पढ़ेंगे, वो बता दूंगा मैं. Then obstruction proceeding under order 21 rule 97 वो ले लेंगे. Then how the court in the obstruction proceeding or execution proceeding determines the right title interest of the parties under the provisions of Order 21, Rule 101, 102, 103, like a 106 last. Okay? That next lecture on Friday will be the last lecture on execution. Please, anybody has any question? It's a very substantive provision, very exhaustive provision, a very inbuilt procedure is made out. It is like a separate proceedings apart from the filing of the suit, written statement, hearing. यहाँ पे भी एक full-fledged trial होता है. But fortunately, in the same executing court, the court where you have filed the suit, but the court once again gives the opportunity to parties to lead evidence, examination, cross-examination, होता है certain matters में. Anybody has any question, please let me know.
Sir, Ashish here, sir.
आशीष बताइए.
Sir, जो आपने अभी example दिया that if you have money from us worth 1 lakh rupees, sir, how will it be proven that it is garnishing money or it is fees due to you or it was actual money that was owed to you for some other reason? And
The
you're not
court
just...
is examining the parties. You have a right to cross-examine him. आप समझे ना आप?
हाँ, sir. So it will become like a trial again, sir.
Ask him to produce the conveyance. The source of money, कहाँ से पड़े? ये पैसा कहाँ से आया आपको? What is your source of income? Do you have privity or nexus between you and the defendant? In the cross-examination under Section 145 the Evidence Act, you can put all question that there is a collusion between you and the judgment debtor. This is in fact his property, which is Benami you are holding. Then you can impeach his credibility under Section 146 and 152, 154 of the Evidence Act. वो सब question बाद में आएंगे. A full-fledged trial होगा. So दूध का दूध पानी. You can out the everything stands naked before the court in trial. That is why full opportunity is given to all the parties under Order 21, Rule 92, Subclause 3. In a suit, there are 4 parties. Number 1, the original decree holder, plaintiff, the judgment debtor. The number 3, the purchaser of the property, auction salesman. Number 3, 4th person who a third party, an independent party filing a separate suit on the ground that here there is a fraud. My property has been attached. The entire proceedings are sham, colorable, and bogus. And the property which has been shown, what is attached is not the property of the judgment debtor. It is my independent property. And by no stretch of imagination or by necessary implication, such property can be attached. How can you attach third party? That is how. Only you can attach the property of a garnishee who is a person claiming under the judgment debtor. समझे ना आप? Who is a trustee? Anybody has any question?
Sir, but where will this trial take place? It will take place in the final court of appeal because that's
executing court.
Okay.
जो court ने pass किया वही court करेगा. Whichever court has passed the decree, suppose the Bombay High Court, courtroom number 2 has passed the order, court number वही court में आएगा, city civil court में, but a judge may change. Judges may come and change and go, but the court will not change. If you have filed a suit in the High Court under the provisions of latest patent clause 12, you are allowed to file the original suit in the High Court. In the Chartered High Court like Bombay, Calcutta, Madras, you have a right to file a suit in the original site. Or a district court, Delhi district court, mein, Thana mein, Pune mein, district court mein can file. In the city civil court Bombay, up to 1 crore you can file it here. In the small cause court Bombay, summary suit or money suit you can be filed up to 25,000. Or immovable property for recovery of property from a tenant or a licensee, unlimited extent under Section 33. So there is no bar. So you should know that the court where you have filed a suit is a competent court, because Section 15, 16, 17, 18, 19, 20 CPC must be curiously gone. Tomorrow I will give one judgment under Order 2182. A court of small causes court passing a decree in the UP, then transferring a decree to the civil court for execution. Small causes court, the property was attached. Because the small causes court has no power to attach the immovable property under Order 2182. पढ़ के आइए आप, Order 2182. That's a very beautiful judgment. I will take it up to how much time out, Mansi, now?
So 2 minutes.
Yeah, 2 minutes I won't be able to cover. tomorrow, Friday, I will cover the judgment under the provisions of Order 2182 of the Supreme Court judgment, where a decree passed by the Court of Small Causes Court and transferring to transferring civil court under Section 38, and that civil court attaching the property, in the hands of a tenant. Now
So what is the name of the case, sir?
I will give the case. The question arose before the Supreme Court was, can such a procedure be is valid or not? They were discussed before the Supreme Court. The name of the party I will give you. At the offhand, I don't have it. I worked out the case law. I kept in my office and get it tomorrow. So the Supreme Court said the decree was set aside following the Chand Pasha's case. You know that 1952 Supreme Court ke andar, if the court is not competent, competency of a court can be challenged at any stage. The decree is nullity. The suit which should have been filed in the Court of Small Causes Court against a landlord, against a tenant for recovery of property, you are filing in Bombay City Civil Court, passing a decree. That decree can be challenged in execution. Similarly, a suit for specific performance of a contract, you are filing in the Court of Small Causes Court, Small Court passing a decree under Section 19 of the Presidential Small Cause Court Act. You know there's a bar. The Court of Small Causes Court cannot try suit for specific performance. It cannot try suit for a preemption or partition. If such a decree is passed, it's a nullity. It may have skipped the attention of the plaintiff or defendant. Maybe parties, dual relationship of the parties may be landlord and tenant. It doesn't mean that you can go for partition. Partition is not allowed because title suit is not filed in the Small Causes Court. Please note that. Title suit only comes to civil court under Section 9 of the Code of Civil Procedure, which is a very wide jurisdiction. So such a decree can be challenged by the judgment debtor subsequently. That is what the Supreme Court says in Chaman Paswan's case. Mansi, if you don't mind, take it up. AIR 1954 Supreme Court. Chaman Paswan's case. Just see that? If it is there. If I am not mistaken, that is the
Kiran Singh versus Chaman Paswan?
Yes. Kiran Singh versus Chaman Paswan. Please read this judgment and come. Following this judgment, the Supreme Court has taken the view in the judgment under Order 21 Rule 82, the Court of Small Causes Court cannot attach the property, immovable property.